morning, and thank you for joining us. So we're going to spend some time today talking about the E-2 visa requirements and renewal considerations. A few things before we get started. Some of you may know that this law firm was founded on an E-2 visa several years ago. Our founder, Ian Scott, is in the US personally on an E-2 visa, so knows what you're going through. The firm is also a full service immigration firm, but we focus primarily on E-2 visas. We processed hundreds of them, and we typically process E-2 visas that are higher risk, so lower investment amounts. We've processed at consulates around the world, but our primary two consulates are Toronto and London. We will continue this webinar series, doing at least 2 webinars a month on different topics. At the end of this webinar, we'll send you a few things. So one is this PowerPoint that you see here today. You'll also get an E-2 visa comprehensive guide and a link to where you can sign up for additional webinars. For our panelists today, we're lucky to have John Barrera, who's an experienced associate at our law firm and has processed many E-2 visas. I'll also be speaking. My name is Kelly LeGrand-Wiener, and I'm the managing attorney at Scott Legal, and have also processed many E-2 visas. If you have questions during the presentation, please send them in the chat box, and we will try to make time for questions at the end of the presentation. And finally, this webinar will be recorded and made available on demand. So without further ado, I will turn the presentation over to John to get us started.
Thank you, Kelly. Good morning, everyone. I appreciate everyone being here, and we're going to try and shed some light on the E-2 visa this morning. So starting off with a few basics on the E-2 visa, just so everyone understands what it is. It's a non-immigrant visa. So what that means is that it's for a temporary period. It's for a temporary period of time in the United States. It doesn't lead to permanent status like a green card does. It's a visa that's based on a treaty. It's limited to certain countries. I mean, there's a long list of countries that actually are part of the treaty, but they are limited. So we need to check what these countries are to determine if an applicant could qualify from that country. Granted, there may be other ways to qualify, even if their country isn't on the list. That's an issue that we do discuss in other webinars, and they could be addressed in those webinars as well. Generally speaking, to obtain an E-2 visa, you have 2 options. You could purchase an existing business. You could start a new business as well as a startup. Generally, in purchasing an existing business, another option, but not really, is purchasing a franchise. It's a very ideal way to qualify for the E-2 business, and we could get more into that a little bit later. Again, it's based on a treaty. It's limited to certain countries, as indicated, countries from Europe, Africa, Asia, Latin America, the Middle East. Finally, the visa is the validity period of the visa. Kind of the term is determined based on the country that you're applying from. There's a term. There's the idea of reciprocity. So depending on what the agreement is with that country will determine how long that visa is. So whatever time that country will grant an applicant from the US for a similar visa, that's generally what the United States will grant their version of the visa, or the E-2, for an applicant from that country. So, but generally speaking, you're looking at about 3 months is the minimum, to up to 5 years. Again, dependent on the country that the applicant is applying from. Okay, so next we're going to talk about like we discussed, you have to be a national of a treaty country. Now, very important, for this application, you have to make an investment. It's important to understand that the funds must be at risk. So as indicated, it states money was actually spent, not sitting on a bank account. So you can't go to an interview basically hoping that the application is going to be approved with money just being saved, even if it's in the business account. The consular officer is going to want to see that money is being used to start up the company that's being spent. Again, that's why the term at risk. It has to be at risk by the time you're applying. It must be substantial. We'll talk about that a little bit more later on. And some examples of E2 expenditures, ideal expenditures would be purchasing inventory, if that's the kind of business you have. Equipment is probably, in some level, it's always going to be a core part of a business, even if you're talking about furniture, but you always want to look at that first. Building a website, office supplies, paying for a commercial lease. I mean, that's very important as well. Marketing, and then setting up, cost of setting up the business entity. So another important aspect, we'll discuss this a little bit more later, is that the business cannot be marginal. We'll get into that, and that involves kind of like the concept of being able to hire U.S. employees, where you're not setting up the business just to kind of pay for your living expenses or your families. The business has to be sort of like the goal is to build revenues, to expand, to hire employees, which is really one of the key cores to this visa. It's kind of building up a base for hiring U.S. workers. Business must be real and operating. So essentially what that means is that the business has to be, if it's not running already and earning revenue, it's got to be ready to go. You're hitting the floor. You're showing that you're going to be hitting the ground running, and it's ready to go. As indicated in the slide, it says already taking revenue or ready to start operating after E-2 lease is granted, signing commercial leases, business entities established, the company website is created. Potentially, you might have contracts with customers. All licenses are essentially being acquired. I'm not saying that you have to do everything perfectly by the time you're applying, but trying to hit those spots in that checklist is what you're trying to do, or coming close to it by the time you're applying for the visa, so the officer sees that this company is ready to go. It's important that the applicant is going to be the person who's going to be solely developing and directing the enterprise. Very important. The applicant has to own at least 50% of the company. Can never fall below 50%. Once that happens, you're essentially putting the visa in jeopardy. You're probably going to get denied in a renewal at that point. And then you have to show that you intend to return to your home country when the visa expires. That's generally not too difficult to prove. We'll generally just provide a short statement by the applicant indicating that intent, but it has to be addressed. That could jeopardize the visa application if it's not addressed, even on a very minimal level. Okay, so the investment. Generally, what we tell our clients is that there has to be a substantial amount. Keep in mind that there's no minimum amount. There's no published minimum amount by the U.S. government, Department of State, or the U.S. Immigration Service. It's going to depend basically on the type of business. Basically, you go into what's called a proportionality test, which is essentially how much money is typically needed to start up this business. That's what the officer is going to be trying to probe for. You have businesses that require a substantial investment, and they're going to be looking for that. So those are the type of businesses that either, are expected to carry large amounts of inventory, or they need substantial equipment, sort of like a factory, where the officer is going to be looking for that type of investment. Businesses that don't require such a large type of an investment, sort of like you're starting up something that's based on an office, like a law firm, it's reasonable to expect that you're not going to be needing too much to invest. There's no large equipment, there's no inventory, a desk, an office space, computer equipment. That's what the officer is going to be looking at, and cost within that area, which would be reasonable under $100,000. Now, you have businesses where it's not really clear how much of investment is really needed for that type of business, and that does happen. We do encounter that. So, so you want to look at ways in showing the officer what that business would typically need as an amount to start up. So you could do that in researching, trying to obtain like business articles talking about typical costs for a certain business, perhaps even looking into a public accountant, a CPA, to provide a letter, kind of like doing a investigation into that type of business and providing a letter as to what kind of costs are going to be needed, or what kind of equipment and costs are going to be involved in starting that business. So when you have a business that you're purchasing now, generally speaking, the officer is going to probably trust that the money that's being paid is the fair market value for that business. So you have to kind of keep that in mind as well. So if the applicant's getting a really incredible deal, that's something that you have to kind of keep in mind, that the officer may, great for the business. You're good, you're purchasing it at a lower cost, but that could be something that the officer kind of questions, whether it's fair market value. So always kind of, even though they're not too picky about that, you have to kind of keep that in mind if you're looking for kind of like purchasing a business for a great deal. Again, franchises are a great option to purchase for E-2 visas. They have a lot of costs already built in, timing to make payments, how to set it up. There's a lot of stability shown by franchises. So officers tend to kind of like that. Common good and bad E-2 visa expenditures. Sometimes we will see a client trying to use costs to, like travel costs to the US to kind of like look to start up a business, that initial trip, that's not really going to work. Paying for, schooling for a degree that may help the business, that's probably not going to work as well. What you want to focus on is kind of like that checklist we just went by previously. Whatever needs to be spent to start up, to build the actual business, that's kind of like your rule of thumb, or your safe space in terms of the best kind of expenditures. So now we're getting into the issue of marginality, and again, probably the biggest part of that issue is the ability to hire U.S. employees. Do you have to hire U.S. employees then? Yes, you do. Essentially, what you're trying to show is that the business has present and future capacity to generate enough income to provide more than a minimal living for you and your family. So essentially, you have to show that this business is going to grow and it's going to have the ability to hire more employees. Must demonstrate that you will hire employees in the next 5 years, ideally at least 3 to 4 full-time employees. That's generally kind of our safe range. That's where we're comfortable at. If the business could hire about 3 or 4 employees during the span of 5 years. Not set in stone. It depends on the business as well. How reasonable it is to hire those employees. It's also about explanation. If it's going to be, if the projections are going to be less than that, you may have to explain why. And it's possible. It just kind of depends on the business as well. But again, 3 or 4 employees is generally our safe space. So, W-2 employees, contractors, generally speaking, W-2 employees are the best type of employees, full-time or part-time. 1099s or contractors, not as ideal, not looked at as favorably. Something is better than nothing, to put it crudely. So, I mean, if it's 1099 workers, I mean, do it, that'll work. Especially if that's going to be your first hire for that first year, definitely do it. It'll work for that first year. But you do want to show, if possible, that within the next 5 years, that you're looking more into hiring these W-2 employees over contractors. That is the stronger case. When you get to the renewal stage, you can renew with 1099s. Again, more explanation, the reasonableness, why contractors over the W-2 employees, if that's the situation. So how do I prove this? Best way for a new business, the business plan. The case is strongly focused on projections. And the officer likes to see that. So that's why for a new business, probably the business plan is very, very important. If you're purchasing an existing business, the history of the business, hiring employees, so the W-2s, the pay stubs, tax returns, earnings reports. That's kind of the best way of showing that that the business is not marginal. All right, so now, do I need a business plan? Again, newer business, I would say yes, because there's no history behind that business yet, and the officers give strong credence to the business to the business plan and those projections. They want to see those projections. They want to see reasonable projections as well. So I mean, if it's a business that realistically generates into the hundreds of thousands, if you're projecting into the high millions, there's going to be questions raised as that. But the key here is you're showing revenues, and you're showing increased revenues in those projections. So generally, what should the business plan contain? The executive summary, that basically indicates who you are, what you do, who you sell to, if it's that type of business. Market analysis and research, basically talking about your competitors, what the market is like, what potential clients are going to be looking like, what they prefer, why they prefer your business, why they might prefer your business. Marketing plan, how are you going to reach out to potential customers, social media, advertising, potentially seminars, things like that, reaching out kind of like to the community to reach out to that core customer base. Personnel plan, so again, projections, 5-year projections of hiring. Also, you need the plan should talk about potential workers or even current workers, job descriptions, salaries, when you will plan to hire each employee. And then again, the comprehensive financial plan, 5 years of financial projections, revenues, revenue assumptions, cash flow projections, and balance sheet. You need to hire a professional. No, not really. I would say my point of view is that the more issues or the more complex the case, the more likely you want professional eyes on the case, whether those are, having an attorney or having a professional build that business plan for you. Just keep in mind that when hiring a professional that do business plans, not all of them will tailor them to what the consular officer is looking for. So again, if you kind of want to have that attorney to kind of review that business plan, just to make sure the key points are being targeted in that plan, to communicate effectively to the officer. All right, so that'll do it for my part. We'll take any more questions again through the chat, and I thank you for your time, and I'll turn it over to Kelly.
Thank you, John. That was great. And we do have some questions that came in, and we will get to those towards the end of the presentation. So let's talk about some E-2 visa developments and adjudication trends. So one thing that we've seen, is, do I need to make my investment purchases in the US? This is a common question. It's something that's not required in the regulations. You don't have to make your purchases in the US. For example, let's say you purchased a lot of inventory, your supplier's, not US based, that's okay. However, we have found over the past few years that it is very helpful to have some purchases in the US. It is something some consular officers will ask about, partly on the thought that, the E-2 is meant to facilitate kind of, economic benefits between the treaty countries. So it can be helpful, and we do recommend making at least some of your purchases in the US, although it is not required, in the legal standard. So something else that's come up a lot recently is administrative processing. So this is something, if your case, let's say you go to your E-2 visa interview, and your case is put into administrative processing. What this means is, rather than being approved or fully denied, you're going to get something called a Form 221G. It is a technical denial. So for example, if you have ESTA, it does impact your eligibility for ESTA. But it's not a full denial in the sense that often when they issue one of these, what they want is additional documents. So you'd either have to submit the documents that they ask for, or sometimes they just may need more processing time. At times when your case is put into administrative processing, it's because not the consulate, but another government agency has requested information about the file. There may be security checks, perhaps running your name has brought something up. And when those other agencies make those requests, there's nothing that the consulate can do at that point other than wait for those agencies to get back to them. So that's just something to be aware of, that when you go to your interview, it's possible to get an approval denial or to get this kind of technical denial, the 221G, where either they are requesting more evidence or perhaps they just need more time to process your petition. So another thing that's come up recently is more USCIS filings. So because of issues with caused by COVID, where there's very low kind of appointment availability at many consulates. Perhaps people are reluctant to travel. Some consulates aren't even processing many visa types still, or are processing very slowly. We're seeing an increase in people filing, their petitions with USCIS. So an approval with USCIS has some key differences that are very important. When you file a change of status or an extension of status, instead of getting a visa, you'll get an approval for the maximum of 2 years. Additionally, this approval doesn't allow you to travel internationally. Once you get the approval, you're permitted to stay in the US and run your company for up to 2 years. But if you depart the United States, then you would have to go to a consulate and submit a brand new visa application and get a visa approval before you could re-enter. The E visa is different than other types of visa, like the L or the H or the O, where a USCIS approval means you can just go to a consulate and get they're basically just going to stamp the visa. The E is different. The USCIS approval does not mean the consulate will necessarily approve you. You have to submit a brand new application to the consulate, and they will review that as a brand new application. They don't have to rely on the USCIS approval in any way. Something else to just note about USCIS is they are generally more accepting of low investment amounts than many other consulates around the world. That being said, they're very strict on the source and trail of funds of the documents. So for many consulates, for example, if you have a source of funds that's your personal savings, you might submit a couple of years of tax returns and proof of you transferring that money to the US, and that might be sufficient. For USCIS, they often want to see a dollar for dollar accounting. So for example, they might want to see bank statements showing an accumulation of your funds over the years, with proof of your payroll hitting your bank account and then where was it transferred. So that's something to keep in mind. If you have a very complicated source and trail of funds, USCIS may not be a good option for you. So another thing that we get asked about frequently is just the impact of the Biden-Harris administration, whether or not kind of in the previous administration there was any impact on E-2s. There wasn't really, and we don't anticipate major changes to the e-visa adjudications under the Biden administration. We haven't seen really any changes. The biggest impact, separate from the administrations, has just been, because of the pandemic, there's kind of lower visa appointment availability and slower visa processing. So that's been an impact, but is separate from, the administration. So let's talk about some COVID issues. Those have had quite an impact on visa processing around the world, including on E-2 visas. So when you're talking about kind of testing, and vaccines right now, still for entry to the United States, you always want to check the CDC website for the most updated information to see, where they stand on testing and vaccines. As of now, you still need to have a test and proof of vaccine to come into the United States. So you want to continue to check those websites, as these things are kind of changing frequently. When you're attending a visa appointment in another country, you also want to make sure you know their entry requirements. It's not so much the case anymore, but over the past couple of years, it was the case sometimes that countries would require you to quarantine when you entered, or the consulates would require you to be in the country for a certain amount of days before you could enter the consulate. Many of them still have masking requirements. So you always want to check, what are the requirements in the particular country, where I'm going for my visa appointment. In terms of consular issues, COVID has complicated timelines for e-visa applications. All the consulates shut down in March 2020. And since that time, they've reopened essentially on an ad hoc post-specific basis. Really, wherever you're applying, you want to make sure that you work with your attorney to understand what the current status is at that particular post, because things really have changed significantly. There are still some posts. So for example, in Bogota, where they aren't accepting any new e-visa applications, even at this time. Every post is different. There are some that are kind of almost back to normal. So for example, London, in the United Kingdom, the embassy is, not quite back to normal where they were post or pre-COVID, but they are continually processing visa applications. You can get your application processed within, a matter of months, versus some of these other consulates where you're looking at, a year or more. Those are more and more the outliers, but things do kind of go up and down. So, as the situation has changed on the ground in various countries in regards to COVID, that impacts the consulate and that impacts what the staff is able to do. So it is a very kind of fluid situation, changing a lot, and something just to keep in mind. So let's talk about some issues and complex areas for E-2 visas. So one, is the source and trail of funds. And this is particularly the case for USCIS filing. So as I mentioned, for USCIS, they're going to want to see a dollar for dollar accounting of where you got your funds. So even if, let's say that you have a parent and they sold a company 20 years ago and they gifted you that money, you are going to need to provide the proof of where that money came from. Even if it goes back many, many years, they will want to see, the purchase sale agreement, the money entering your parents' bank account, any taxes that were appropriately paid, and then where that money was over the years. It is something to keep in mind that if you are going with the USCIS, you want to make sure you have that dollar for dollar accounting, and possibly kind of work with your attorney if you have the option of multiple sources of funds to pick the one that is the most straightforward and the most easily documented. One thing to note is that, you can have a gift for an E-2 investment. You can be gifted it by a friend, a family member, your spouse, can gift you the money as long as you're able to show where they received that gift money from. You cannot have a loan that is secured by the assets of the E-2 company. So this also comes up sometimes where clients are buying a business and perhaps they want to do some type of seller financing. Usually in those circumstances, if there's seller financing, the loan is secured by the assets of the E-2 business. That is not permitted for the E-2. So if you're going to be financing your investment with a loan, you want to make sure your immigration attorney is reviewing that loan agreement before you finalize anything, because any loan that's secured by the E-2 company's assets is not okay. If it's secured by your personal assets, that's fine. So for example, you have a home, you take out a home equity line of credit. That's completely fine. Also, a personal line of credit from a bank, that's also permitted, as long as it's not secured by the assets of the E-2 company. One other thing just to keep in mind with loans is that you want to also look at the repayment terms. If the repayment terms are extremely aggressive on an unsecured loan, sometimes the officer might be concerned the business is too highly leveraged. So that's just something to keep in mind. If you have funds to show that you'd be able to pay it off and it's realistic, that's okay. But just something to keep in mind with if you're pursuing a loan for your E-2 investment. Another complex area is kind of small investment amounts. Some investments are just going to be too small. If you're investing $10,000, that's just pretty much never going to be sufficient, even with somewhere like USCIS that accepts, lower investment amounts. If you have a small investment, so if we talked earlier, something under 300,000, it's important that you explain why your investment is substantial. So it can be helpful to provide market or industry reports from respected publications with estimates for how much the startup costs are for your type of business. Sometimes, different business publications or magazines will, write articles about this, and those can be helpful sources of evidence. When you have a small investment amount, it's also very important to make sure that the other parts of your application are as strong as possible. So make sure you have good proof, of real and operating, your business entity is set up, your licenses are obtained, your company's ready to start operating once you enter the United States. Have a detailed business plan with financials that make sense. Be able to show contracts or letters of intent from prospective clients that are interested in working with you. You may also get letters from local business organizations. For example, a chamber of commerce may be willing to meet with you and write a letter supporting your application, writing about how you're bringing jobs to the area and economic growth, and that's what they want to support. So those types of things are very helpful if you have a small investment amount. Something else that comes up a lot are E-2 visas for two investors. If this is the case, if both of you are trying to get the visa, your ownership has to be 50-50. Even if you have a US business partner, your ownership has to be you as the applicant, you must own at least 50%, or more. If the both of you are trying to get the visa and you're owning the business 50-50, ideally you would want to invest around an equal amount. You also want to make sure that each of you has a specific role within the company, explain why each of you are necessary to run the business. Perhaps one of you is the CEO and one of you is the CFO. You can kind of assign the roles based on, what makes sense given your particular backgrounds. Additionally, some consulates, if you are, both of the same nationality or live in the same place, some consulates will allow you to be interviewed together. So, something to keep in mind. Something else that comes up frequently are, questions about what happens if there are changes to your business after you file for your E-2. So if there's a change to ownership, let's say that you start your business and then you want to sell part of it. Your ownership your company must always be at least 50% owned by treaty country nationals. If you want to continue to be the investor, you yourself personally must continue to own at least 50% of the E-2 company. If the company ever falls below 50% ownership by treaty country nationals, it is no longer eligible to be an E-2 company. So that's something you always want to keep in mind. If there's ever going to be changes to ownership after you get your approval, always speak with your immigration attorney first, because even if you have a 5-year visa, if your ownership drops down to, let's say, 20%, and the treaty country nationals don't own, at least 50% of the company, your visa is technically no longer valid. You're not maintaining that status because you're no longer eligible under the requirements. So always important to speak with your attorney before any changes to ownership. Similarly, any changes in your business line. So if your business is changing dramatically, let's say you were running a consulting company and now you want to open a restaurant, you do need approval before you can start the new business. It's not possible to just completely shut down your consulting company and under that same LLC start a restaurant. First, you would either need to go to USCIS to get an approval or back to the consulate. And that would probably involve showing all the elements of the E-2, a new investment into this new dramatically different business line. However, let's say you're running your business and you have a marketing company and you'd plan for your niche to be finance professionals, but instead it turned out you got a lot of healthcare companies as your clients. So, but you're still offering marketing services. It's really still in the same business line. In that type of circumstance, it's not considered a substantive change and you really don't need to do anything you don't need to report to the consulate. You can still just continue to run your business. Similarly, if you are starting a new business line, but it's within the same framework, for example, you're a wedding photographer and you start a wedding blog, those types of things really are not considered substantive changes. That's really kind of an expansion of your current business line and something that you don't need to get approval before you start. If you know that you want to start multiple business lines, let's say you want to sell software or IT services, but you also want to do mobile app development, but that's going to be farther down the road. You can contemplate that in your initial business plan. So let's say in your business plan, you'd say, I'm going to be doing my software services, and then in the future, I'll be doing mobile app development. So now that's already been reported to the consulate, and you don't need to go back and ask for any additional approvals. So that's another way you can kind of build in multiple business lines at the beginning of your application. Something else that's quite complex are kind of family business purchases. So as John mentioned earlier, if you're purchasing a business, on the open market, um, you know, oftentimes you're not going to really be questioned as to whether your investment's substantial because it's the fair market value of the business. If it aligns with the financials, and it's a kind of third party that you don't know, that can often be considered substantial. If you're purchasing a business from a family member or related party, then sometimes you need to do some additional work to make sure that the officer feels comfortable that this is really the fair market value of the business. So you could get a third party valuation. You could have a CPA look at the financials and write a letter. And then as well, just there should be when you look at the financials, when you look at the balance sheet, the tax returns, it should be clear that the amount that you're paying, whether it's an asset or an equity purchase, makes sense in light of what those financials are reflecting. So you want to have that information ready if you're purchasing from a family member so that the officer, inherently it's going to be a more suspect purchase. But if you have that evidence, then they may feel more comfortable that this is really the fair market value, for this business. So some common reasons for E-2 denials. So one is low investment amount. If the investor has more money to invest, this can be a relatively easy fix. You can just invest more money and you can reapply. You can also gather more industry evidence to support that the investment amount is substantial. Another reason may be nature of the business. So some businesses are just riskier than others. For example, a consulting business that has no proof of client contracts. An officer might be concerned for a consulting business also that the person is going to open just a one-stop, they're really not going to hire employees. It's just going to be them operating as an independent consultant. And that's not what the E-2 visa is for. Similarly, for businesses such as real estate, they may be worried that you're just going to, passive real estate ownership. You own a home and perhaps you're going to flip the home. That's not considered active enough, to be an E-2 business. Another thing that can come up are filing location and venue. Some consulates are just more E-2 friendly than others. Toronto and London are two good examples of very friendly, organized E-2 consulates. There are some places that are just not familiar with the E-2 at all. That can sometimes be a benefit if they're open and they're able to kind of review your application and understand why you meet the requirements. But it can also lead sometimes to misunderstandings where they, kind of put forth different requirements that are not actually accurate. Similarly, there are just some consulates that are not very friendly, for visa adjudications and for E-2s as well. In terms of USCIS as a venue, as we've discussed, it's less concerned with issues like lower investment amount. So it may be good for you if you have a low investment amount, but it does require that dollar for dollar accounting of your source and trail of funds. Another thing that can come up, if you have been running a business in your home country for many years and you don't have any employees, that can be a red flag. They may not, even if you have a good business plan that shows your plan for hiring employees, if you've been doing this in your home country for many years without employees, they just may not believe you. So a good way to combat this is, you can hire an employee, before you file, so they feel comfortable that you've already, gotten over that hurdle. There may also be concern over whether the business will create jobs for U.S. workers. So to meet the marginality requirement, you do have to prove the company will support more than just the investor and their family. And the business plan should explicitly address this and explain how you will hire, U.S. workers in the United States. If there's a big concern about this, again, you can hire an employee, before you file. Any money you pay, for the employee can be part of your investment, and any ancillary employee related expenses like a payroll provider can also be included in your E-2 investment. Some people have issues with their adjudicating officer. Most of the time our clients experience, have good experiences, or, the officers are polite, professional. But there are times when you encounter an officer who is less than, than you would hope. In that case, you have to remember the officer has complete discretion over whether to grant or deny the visa. There is no appeal process. So you want to keep that in mind. You want to be as polite as possible, even if that's not what you're getting from the officer. If they tell you they're going to deny you, you can ask them, what it was that they were unhappy with. because there is nothing that stops you from trying to address those issues and reapplying. If you reapply, most consulates will try to make an effort to give you a different officer. It's not a guarantee, but most consulates have that procedure in place. Another reason may be you didn't meet the requirements at the time of filing. There was perhaps a poor file that just didn't include what was needed. Some clients have come to us after a denial like that, and we've been able to rehabilitate the file and send it in and get an approval. For example, we had a client who came to us, they had spent $2,000 and put $98,000 in a business bank account. So there was not a substantial investment. The funds were not committed. They were not at risk. So they just did not meet the requirements at the time of filing. However, we advised him on how to spend, funds in different areas. And, ultimately he was approved after that. So what does it take to renew an E-2 visa? Hiring U.S. workers is key. As John previously mentioned, we recommend at least 3 full-time equivalents in 5 years. The salary doesn't matter as long as you're meeting kind of Department of Labor requirements. So you can't be paying, under the minimum wage. It needs to be at least that. Hiring is very important for an approval. I think as John mentioned, you can also include proof of the independent contractors, and depending on your industry and the amount of money you paid to these independent contractors. So let's say you paid hundreds of thousands of dollars to independent contractors, perhaps you're in construction or, another type of business that frequently pays large amounts to independent contractors, that can be very helpful. That being said, we still recommend having at least 3 full-time W-2 workers if possible. It just, makes it a lot stronger to have those employees on top of the 1099s. And for many, people, if you're applying with just 1099s, it's going to be quite weak, particularly if you haven't paid them a very large sum. So it just is very important. And many consulates for a renewal, they're going to focus primarily on your tax returns and your W-2s and 1099s. So if you don't have those, it's going to be very, very difficult uphill battle for approval. So another thing you need to provide for renewal is this updated financial data. So tax returns, often 2 years, sometimes 3 years. Some consulates ask for all tax returns since you were approved the last time. You want to look at, did your company meet its revenue targets? It's fine if your company didn't meet your business plan targets, as long as it's earning enough money to support employees and yourself. Consulates, I think, will rarely point back to the original business plan as long as the company is doing well. So let's say in your business plan, you said you were going to be making $1 million in revenue by year 5, but you're only making 700,000. That's completely fine. And there would be no need to mention your business plan targets. We know those are projections. The consulate knows those are just projections, but the fact that you were making the 700,000 and able to hire employees would be very important. Another thing to consider is the company profitable? So revenue is much more important than the net profit figure, but showing profit is good for the application. It's not a problem if the company is running a small loss, as long as the financials show good cash flow and an ability to keep paying employees. However, you would want to have, some explanation for the loss. For example, many businesses, did poorly in 2020, but now if you're reapplying, you want to be able to show that you're on the upswing with your application. We already talked about, you want to include your payroll information, your W-2s, your 1099s, an explanation. Let's say that over 5 years, you hired 10 employees, but you only have 2 employees now. You would still try to include that other, proof of the employees and explain, why, there was employee turnover. That's completely understandable, but it's helpful to show that over the years you'd hired and paid, 10 US workers. You can also discuss whether your marketing and sales plan worked effectively to increase your business volume. So your cover letter and the renewal should highlight any company achievements. Good to highlight any success that you've had. For example, if you've signed large clients, if you've gotten positive online reviews, if you've expanded your service offerings within that same framework of your business offering, if you've purchased new equipment, all of those things can be included, to help show the business is doing well. If the company is not doing well, you can show your plans to hire employees. So you might include kind of a mini business plan. For example, if you had to lay everyone off in 2020, but you have active job postings now. Those types of things could all be included in your renewal application. And then as well, you need to show your company is still meeting the E-2 requirements. So if there's been any changes in ownership, you still need to show that the company is 50% owned by treaty country nationals, or, if you're the investor, that you still own at least 50% of the company. Good thing to note is if any of your employee or any of your owners are treaty country nationals, but also green card holders, their nationality will not count towards that 50%. So if you have an owner and they are transitioning to get a green card, you want to talk to your attorney first to figure out whether that company is still going to be able to be qualified as an E-2 company. Similarly, changes to your business type. We talked about that, at length previously. If there's been any changes, those should be reflected in the application. Your company should still be providing the services it represented in the initial application. It's okay if it changed due to market forces, but if your business line changed entirely and you didn't report this previously, that could be an issue for your renewal. So let's now get to some questions. I'll take some, and I'll also ask John to jump in. So someone asked, would you know if consular services are back to normal in Sydney? So unfortunately, no. Sydney, to our knowledge, is still closed. Melbourne and Perth are processing E-2s and are both quite backed up at this time. Hello, we're a UK citizen family planning to do our E-2 application in London. Friends in USA are looking for a small independent motel. What is the maximum funds required? Is it possible before I start my application, can my friends buy the hotel with a partner? So, I mean, in terms of what's the maximum fund for an independent motel, there's no maximum fund. Again, it should make sense in light of kind of the financials of the company, or of the worth of the assets. Probably, you want to, if the actual asset amount is low, like if you're purchasing for 30,000, you want to be making some ancillary expenses, to show that you spent everything necessary to get, the motel up and running. So is it possible to purchase part of the motel from, friends of yours who've just purchased the motel? Yes, that's possible to do, but also just consider what I said about, business purchases with related parties, that there's going to be kind of some additional scrutiny there. And you want to show that it was, that what you're purchasing was for fair market value. There's a question for John here. In 2014, my husband had a cannabis charge that was later withdrawn. Will this affect his chances of E-2 approval? He has the documents proving it was withdrawn. Or if you were the sole applicant, would it affect their chances?
Yeah, thanks, Kelly. So generally, these criminal-related questions are a bit complex because it involves analyzing what actually happened in the court. Generally, and it depends on the jurisdiction, like where did this case happen? If it's in the U.S., what state? If it's abroad, what court? How do they define certain terms? Like, for instance, you mentioned that the charge was withdrawn, and that implies that there was no conviction. So if that was the situation, you're in good shape. But you also have to keep in mind that when you're talking about criminal violations, that especially when you're talking about drugs or what the government refers to as controlled substances, it's not always about whether there's a conviction or not. Sometimes admitting to committing a crime, even though there wasn't a conviction, can also put in jeopardy an immigration benefit application. So the bottom line is that, a simple way to answer your question is that the visa application is probably in good shape because it was withdrawn, but you still want to have an attorney look at it just to make sure withdrawn means withdrawn for the purposes of the U.S. government, and also the circumstances of the potential allegation against the person, to make sure either it's not going to be an issue at the interview, or to be prepared to know how to address the issue at the interview to mitigate the chances of the case being denied.
Perfect. Thank you. Someone's asked about the total wait time in Toronto. So this is kind of changing frequently. We just had a client where we submitted for the E-2. They were told to schedule their interview after 10 days. They scheduled an interview for November, but then checked back each day, and were ultimately able to get an appointment in July. How long do you need to wait until you can apply for a change of status from the time you enter on a B1, B2 visa? This kind of depends on the conversation you have at the border. For example, if you come in and say you're coming as a business visitor, and they specifically, get you to say you're going back to the consulate, you don't want to kind of file a change of status right away, because that's inconsistent with what you've communicated. So, probably want to wait, a few months, so you can kind of reasonably explain, if your mind changed about, why you're going to change your status rather than go to a consulate. So what's the minimum I should invest? We went over this in the presentation. Really, it's going to depend on the type of business you're starting, and also where you're applying. At more friendly consulates that accept lower investment amounts, 50,000 or 60,000, with at least half or more of that spent is going to be kind of a minimum amount. But it really depends on the type of business you're starting. For some businesses, that's like a manufacturer, that's not acceptable. For a change of status, because the applicants start the business before you apply, it depends what status you're on. You want to be careful about what you're doing depending on what status you're on. So, if you're as a business visitor, there's certain things, you may be permitted to do, have a meeting with the, commercial lease owner to get a lease in place, but you don't want to start kind of meeting with clients or taking in revenue. Okay. Can you apply in a different city in the same country? Say a Sydney resident files in Melbourne. What is the current processing time in Melbourne? I'll give this to John. I know he has a case pending there now.
Yeah, so it's a little hard to say right now. You can apply and request the case from Melbourne. If you do that at the start of the case, it seems like the consulates are doing that. It's a little bit more trickier. Like, for instance, we have some cases where we've applied through Sydney during a time where it seemed like they were going to reopen, and they never did. Well, they're still kind of shut down. So right now we're trying to get Melbourne. We have another case where we're trying to get Perth to maybe take those filings. It has been done in the past, but there's no kind of set criteria or process to get them to do that. You kind of just have to, poke them and try and get them, to respond and eventually take the case. So it's possible to change the case if you're in that situation. You just kind of have to be insistent. And if you're filing anew, you can file through another city in Australia.
Right. Melbourne and Perth are kind of the two active posts right now. Sydney is still not operating yet. So somebody asked, with regards to the point about business being established, does this apply for a change of status? If I'm already in the US, can I start this business? I think we answered, this question already. You should be careful depending on what status you're on. Someone asked, what's the minimum employees? Again, we recommend about 3 to 4 full-time by 5 years. All right. Would Airbnbs qualify for an E-2? That's going to be, again, under real estate. So risky. If you're doing property management services, if you're not just a passive owner, a passive owner, no. If you have many properties and you're providing property management services, potentially. Does having an existing B1 and ESTA impact the E-2? No, it does not. Let's see. Someone's asking about our legal fees. It's something that you can certainly contact us separately, send an email to our, our email address, and we can send you our engagement letter with our fees. Have E-2 visa renewals been going through smoothly since the pandemic, or due to renew in August? It depends on where you're applying. Places like London and Toronto, generally, yes, as long as you can kind of submit updated documents if you've been pending for a while, but things are taking longer. So you want to kind of start your renewal sooner, than you would have otherwise. We've been contacting people about a year before their visa expires, because consulates are just taking quite a long time. What are the chances to get an E-2 visa after getting approved from USCIS in Toronto? it just really depends on how well the business is doing. Toronto does tend to scrutinize these quite closely, so you want to make sure the business is doing very well. Toronto is as I mentioned, the timelines. I mentioned the timelines earlier, so those are as back to normal as I think we have. UK citizens need to be residents in the UK. Is there a time requirement to be a resident? I'm currently living abroad, but considering relocating to file the E-2 application. So there's no time requirement. They look holistically. It's something you should kind of discuss with an attorney because it's very fact specific. Like if you've lived in the UK your whole life, you lived abroad for a couple of years and now you're moving back, that's likely fine. If you've lived outside the UK most of your life, it's going to take a bit longer, I think, to holistically establish residency. Someone's asking about a copy of the Zoom session. You'll be sent a link and the video will be available on demand after the webinar. Do I need to apply now and have things ready, or apply when I'm ready with the business offer? I'm not sure what this means. Clients come to us at all stages of the process, including the very, very beginning when they're just getting started. What's the minimum investment amount? So we've already addressed this question. It's going to depend on your type of business. Do I need to travel back to my country to renew my visa, or can I file it in any other embassy? So right now, most embassies are not as friendly to third country nationals as they used to be. If you're in the United States and running your business, you do have an option to try to renew in Toronto. So that's kind of one of it, option available to you. Canada is still accepting third country nationals at this time, but many other embassies are still not. So you want to kind of check on that. And it does change frequently. For example, Frankfurt was previously accepting them, but then got very busy and now they're not. More questions about the length of time in Toronto, which we already addressed. Are they considering for renewal the COVID economy? I think yes, like they're, the consular officers are human beings, and your application should address kind of what's happened, but should also show how your company has, taken steps to get back on a path to success. For example, like new contracts, different service lines, that you're hiring. Can I apply for the E-2 visa at the consulate in Toronto while it's pending? I'm in the States and I fly back to Toronto for my interview. So yes, if you're in the United States running your company, you can apply in Toronto and then submit your application to Toronto and just fly in for the interview. That's fine. In E-2 adjustment, in E-2 adjustment of status, can travel back to Canada. I'm not sure what this question is asking, but so as I mentioned, if you are in the US in your E-2 status and you apply in Canada, you can fly there for your interview. Someone's asking about processing times in Morocco. I'm not aware of the current processing times in Morocco at this point. So those are all of our questions. So I want to thank everybody for your great questions and your participation. Thank you so much, John, for sharing your knowledge. And we will, you'll be getting a copy of this webinar, as well as the other documents I mentioned at the beginning of the webinar. So thank you, everyone, and have a great day.